Welcome to TP Talks, PwC's Global Transfer Pricing podcast series. My name is David Ernick. I'm a principal in the Transfer Pricing Group in PwC's national office, and we welcome you to this episode covering recent Dutch transfer pricing developments. Joining me in today's podcast, we have from our PwC Netherlands transfer pricing team, Aleks Davydov, a senior manager, along with Schaatsbergen and Niek both of whom are directors with PwC Netherlands. Welcome. Before we dive into our technical discussion, it may be helpful to have a little background on the Netherlands and its role in the world. I have never actually been to the Netherlands, although it's on my bucket list to do so. But I do have several Dutch friends, and I remember when I used to work at the Treasury Department, I would attend OECD meetings in Paris, and our team was close with the delegation from the Netherlands. They were always technically excellent and wonderful people overall, but I do remember it seemed that I was always looking up when I was speaking with them. It seemed that everyone was very tall, and I believe that the Netherlands still has the tallest average human height among all countries. But Aleks, before we begin discussing the latest Dutch transfer pricing developments, can you set the scene for our listeners and give us some high-level background on the Netherlands from a local's perspective?
Thanks, David. The Netherlands is a relatively small European country, which is known for its windmills and tulips and cyclists and beautiful canals. And in the tax world, it is also known for its sandwiches that were quite popular not so long ago. Thanks to its open economy over the last decades, many multinationals have found the Netherlands to be a convenient gateway to Europe. Most recently, Brexit also played a role, as Amsterdam is sometimes viewed as a new London in a way, with many people and companies moving here. When it comes to transfer pricing, the Dutch authorities are known to be quite advanced in their understanding and application of TP rules, which are OECD-based. From time to time, they issue legal decrees which aim to provide guidance to taxpayers on how they actually apply the arm's length principle in practice. These decrees tend to be very insightful, as they go beyond the standard OECD text, and thus will be of interest not only to the Dutch taxpayers, but to the most of TP practitioners globally. Last month, the Dutch authorities published not one, but two such decrees. One focused on transfer pricing, and another covering the attribution of profits to permanent establishments. Neil and Niek have gone through these documents and are eager to share their insights with our listeners.
Very good. Neil, perhaps you can kick off the discussion with the TP decree and explain what's in it.
Thanks, David. More than happy to. The new TP decree replaces the last one, which dates back to 2018 and incorporated the outcomes from the OECD's BEPS projects. One of the key points that the OECD still needed to address after that BEPS project was that they hadn't really covered transfer pricing of financial transactions. The OECD came out with their final guidance on the transfer pricing of financial transactions in February 2020. This latest TP decree now reflects these changes as well. The reason it took so long to publish the new TP decree is that the OECD introduced some concepts that are not aligned with Dutch case law, covering the recharacterization of debt into equity. The new TP decree reflects these uncertainties on recharacterization, especially when external debt is covered by a guarantee from a related party. In general, there's been an increased focus on substance and functionality for financial transactions, and not just looking at the contractual terms of the underlying agreement, which has mainly been the focus in the past. This new TP decree includes new guidance on the remuneration of so-called financial services companies. And these are Dutch companies that act as an intermediary for financial payments within a multinational enterprise. The guidance included in the new TP decree replaces the guidance previously given in another decree that specifically addressed these financial services companies. And a part of that decree is now actually being revoked, specifically being the part that covers the TP methodology. Whereas this older decree suggests a remuneration based on a spread between the income and the expenses, according to a somewhat formulaic approach, this new decree no longer mentions that specific approach anymore. The new decree emphasized the importance of control over risks and financial capacity, which then determines the remuneration. A distinction is now made between different scenarios where the financial services company has either full control, shared control, or no control over the underlying financial transactions. In cases where there's no control, a cost plus is considered appropriate for the financial services company based on its operating expenses, where an arm's length interest rate is mentioned for the two other scenarios, but then also in combination with the overall financial position of that company. This suggests that a spread may still be appropriate, but it's also important to have substantiation of the interest rates applied on those underlying loans. Interestingly enough, the decree suggests that shared control will only be seen rarely, but if so, then it would be appropriate to share any risks that may materialize between the parties controlling those risks. Overall, the new decree creates more uncertainty on how to remunerate an entity that is interposed between financial flows. The new decree also includes more guidance on the impact of subsidies on transfer pricing, specifically addressing the impact of government aid during the COVID pandemic, although the guidance is fairly generic. Other changes are also included in the decree, but most of these tend to be more tweaks than big changes. And the biggest ones are the ones I've just mentioned.
Excellent, Neil. So this is yet another example of a tax authority updating its transfer pricing rules after the OECD's BEPS project regarding how to deal with transfer pricing of intercompany financing, along with some general guidance regarding government aid provided during the pandemic. Let me ask you, Neil, what types of intercompany transactions could be impacted by these developments, and what should companies be doing now?
Well, all multinational enterprises that have intercompany transactions in the Netherlands are likely affected by the new decree in some way or form. However, those that have financial transactions involving a Dutch resident company will be most affected, especially those where they have back-to-back transactions. But the same applies to third-party lending, which is guaranteed by either the parent or some other group company. The new decree puts a lot of emphasis on the control over risks and financial capacity, and the most affected setups will be those where local presence in the Netherlands is thin. Examples would be a company that is run by a board of directors where half of the directors are not resident in the Netherlands, possibly in combination with the administration outsourced to a trust office or some other sort of third party, who may then also actually be a provider of the Dutch resident directors. For these companies, it may be recommended to assess and document that they meet at a minimum the Dutch operational substance requirements, so that at least there's a mitigation of the risk that there's a potential discussion that that could result in the denial of certain tax treaty benefits. For situations that are less black and white, it would be recommended to perform an analysis that demonstrates the involvement of the representative of the Dutch company, both in the assumption and the management of risks that are coming forth from financial transactions, and to also have evidence available to support that position from the company itself. In short, a more comprehensive functional analysis for financial transaction that addresses the various parties involved has become more important, and now would also be a good time to review any intercompany financing policies.
So again, that shows the continuing focus in determining arm's length pricing on operational substance in terms of qualified individuals managing and controlling risk. Thanks a lot, Neil, for that summary. Let's move now to the second decree Aleks mentioned. And Niek, can you share what's in this decree with us, please?
Absolutely, David. So the second decree revolves around the profit allocation to permanent establishments. And this is relevant to determine the profit or loss exemption or a tax credit in situations where there's either a Dutch entity that has a taxable presence abroad, or where there's a foreign entity that has a taxable presence in the Netherlands. The latest version of this decree was already from 2011, so it was about time for an update.
So what exactly has changed in the new decree, Niek?
Well, it's been mostly updating the decree for all the international developments that have taken place since 2011. But the most notable updates are the manner in which the Netherlands prevents double taxation, which is now since 2012 through a domestic exemption of foreign profit or losses. Another important development since the last decree was the OECD G20 BEPS action plans and the 2018 profit allocation paper that related specifically to Action 7. The third development is the references to other decrees that provide guidance on how to request initiation of a mutual agreement procedure or how to obtain certainty in advance through a ruling on either the profit allocation to a permanent establishment or indeed the absence of the existence of a permanent establishment at all. Content-wise, not too much has changed, although if you look closely, there are some nuances. So the Dutch State Secretary is even more explicit than before that the latest version of the authorized OECD approach should be followed to determine debt and equity financing of the branch activities and which interest costs should be attributed to the PE. And even to treaties that predate the latest version of the OECD approach. So, and for extra clarity, even numerical examples are given. A second nuance is that the State Secretary clearly caveats the policy that the tax authorities will apply in situations of double non-taxation. And although this makes sense in the current day and age, one could debate whether there is sufficient legislative basis for this. So that's an interesting topic. And lastly, there's also less guidance on how to deal with the old, so the pre-2008 methods of profit allocation. Frankly, because it's largely lost its importance. At the time, it was a relevant development. Now it's already 14 years old. And it's also to do with the dynamic approach that the Dutch authorities take to treaty interpretation, which means that the Netherlands considers the latest OECD guidance for the interpretation of treaties where possible, and prefers the use of the latest version. But despite this progressive approach, the State Secretary of Finance has indicated that where another country would apply a more static approach, so use the older versions to old bilateral treaties, the Netherlands would follow the source country approach, subject to certain conditions, mainly the fact that it should still be at arm's length. But it's in itself, it's not new, but it is a valuable remark that really adds to the avoidance of double taxation and the taxpayers' certainty on their tax burden.
And from your perspective, is there anything that is missing from this decree?
Well, overall, we can summarize this decree as a welcome update of the old decree with many updates. The Dutch rules continue to follow the general direction of the OECD. But then, in my view, it's a bit unfortunate, actually, that the State Secretary of Finance hasn't taken this opportunity to publish more policy on, for instance, the profit allocation to management PEs as a result of dispersed management, or the use of home office PEs post-COVID. There's a lot of tension in the market there, and I feel this would have been a great opportunity to take some of that away.
So it sounds like the new decrees provide good insights as to the approach of the Dutch tax authorities, but there's still some uncertainty how this would be translated into company-specific situations. Let me ask you, Aleks, how can taxpayers deal with this in practice?
Well, having a well-thought-through transfer pricing analysis and documentation that is based on high-quality functional analysis and economic analysis will go a long way to help companies support the positions taken. There is also a well-established APA program in the Netherlands, which could help deal with uncertainty in specific cases. Although historically the Dutch tax authorities have not been willing or able to conclude APAs on financial transactions, this may now be possible with the inclusion of Chapter 10 in the TP decree. Overall, we have had a very good experience working with the Dutch tax authorities, and it is certainly helpful having them at your side in case of a bilateral APA or a mutual agreement procedure. It is worth noting that access to the APA program does require economic nexus in the Netherlands. This means that there will need to be significant operational activity if the APA request relates to a financial transaction. But with or without an APA in the Netherlands or in any other European country, a proper functional analysis is critical. When I say proper, by that I mean an analysis that is based on actual facts that may, of course, change year on year. So companies need to be able to demonstrate, for example, how many people in which roles and functions, in which grades, in which locations work for them, how that evolves over time, and how that links to value creation. Once you get hold of these facts and data points and they support your story, then it becomes easier to get everyone on board with it.
So, as we approach the conclusion of our podcast, it seems that this is all consistent with the themes that we're seeing from the IRS and indeed from many tax authorities around the world. I really can't emphasize enough how important it is, as Aleks said, to perform a high quality functional and economic analysis and document those accordingly. There really are no shortcuts here, and it is important to consider the importance of having the Dutch tax authorities working with you in the APA or MAP context. But before we sign off, what are the key takeaways from these two decrees? Aleks, how would you summarize?
Well, in short, the Dutch rules continue to follow the latest TPA developments. And similarly, the PE attribution rules were refreshed in line with the OECD guidance. So there is no surprise in this regard. We do expect some uncertainty in relation to the financial intermediaries, as there are many shades of gray between a letterbox company and a full-blown treasury center. Taxpayers will have to perform a proper substance review to support their position and have it documented in their Dutch local files. The good news is that the Dutch APA program is available for all taxpayers with an economic nexus in the country, and that the Dutch tax authorities are very advanced in their understanding of the arm's length principle. So we can speak the same language with them.
Very good. I think that's an excellent summary. And with that, I want to thank Aleks, Neil, and Niek for joining me today. Please stay tuned for future podcasts. Thanks again for listening, and have a great day.
This podcast is brought to you by PwC, all rights reserved. PwC refers to the U.S. member firm or one of its subsidiaries or affiliates and may sometimes refer to the PwC network. Each member firm is a separate legal entity. Please see www.pwc.com/structure for further details. This podcast is for general information purposes only and should not be used as a substitute for consultation with professional advisors.